Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It is Saturday morning the 28th of June. And today we're going to Idaho. I'm going to talk about Bryan Kohberger. Bryan Kohberger, of course, is the accused of the quadruple murder of 4 University of Idaho students way back in November of 2022. Kohberger's trial is set. It's set in stone. It's set in stone according to Judge Hippler. Jury selection is due to start at the beginning of August, and then a couple of weeks later we're going to get opening statements and one of the biggest trials of this year. As we're only a little over a month out now to the trial, documents in the case are going to come thick and fast. So I want to spend some time this morning talking about the case. The Judge Hippler, has put in 2 orders over the last couple of days. One of them, the decision on the defendant's motion to continue the trial. The defence want the trial to be continued because they feel that they've still got too much to do and it's going to be prejudicial to Bryan Kohberger to do the trial in August. But Judge Hippler has said no in a very, very long order. So let me know in the comments if you want me to do a live stream going through that entire order. It's really interesting. So if you're following the case, let me know in the comments. Actually, what I want you to do is let me know if you're following the case still at all. I'm not too sure how many of my audience are still following the Kohberger case. So do let me know in the comments if you want me to continue to cover Kohberger and the entire trial. So that's something for you to do. Also, let me know as well if you're interested in the Barry Morphew case, the murder of Suzanne Morphew, 49-year-old woman from Salida in Colorado. That case goes all the way back to 2020, and it's been a long and winding road, but Barry has been re-indicted. So let me know if you want me to cover that case as well. I'll be following both of the cases really closely because I've followed them, both of them, from the outset, from day one in Kohberger's case and almost from day one in the Morphew case. So yeah, let me know. And also, if you're here and you listen to my videos and you're not subscribed, please subscribe. It's completely free. And I'm trying to get to 100,000 subscribers by the end of the year. I'm almost on 91,000 subscribers now, so I think I can make it. But I do know that a lot of people who watch my channel don't subscribe for whatever reason, so please do. It's going to take a second of your time and it's going to really help me out. Alright, so what we're going to do in this video is we're going to go through this document. Really interesting, only 7 pages. We're going to read it and I'm going to give my comments on it. Full disclosure for those who are not sure what my stance is on the Kohberger case. I think Kohberger's the guy. I really do. Look, I haven't seen any evidence to the contrary. I know that there's a lot of people think that he's been set up, he's innocent, etc. I'm not one of those people. However, I always maintain an open mind, and if stuff comes out at the trial that starts to change my mind, then you've got to believe that I'll say so. But for this moment, at this moment in time, I do believe Kohberger's the guy. But, of course, he's constitutionally innocent until proven guilty. So this order somewhat surprised me for one particular reason. I'm going to go through it. Let's go. So this is the judge's order. It's been redacted. There's some bits that are just all blacked out. So that does hamper our understanding of this alternate suspect theory somewhat. We're not going to get the names of the people who the defence believe are the alternate suspects. Alright, redacted order on defendant's offer of proof re alternate perpetrators. The state previously moved in limine. In limine means when they want to add something or take something away from the trial. So something that they want to include or something that they want to exclude from the trial. So the state previously moved in limine seeking to preclude defendant from offering or arguing alternate perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on this motion, defendant filed his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State v. Meister, which is an Idaho case in 2009. Defendant conceded at oral argument that at this point his proffer is not sufficient to pursue an alternate perpetrators theory at the outset of trial, but requests latitude in cross-examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. That's fair enough. Listen, I'm all for a rigorous defence, and Kohberger's defence team, they're doing their job. Just because I believe Kohberger's the guy, I'm not going to say that I think the defence are doing anything wrong. They're trying everything they can to get as much evidence in to this trial as possible. In the last year, we've seen 2 big trials where alternate perpetrators have been discussed. The Delphi case from Indiana, personally, I believe Rick Allen has been wrongly convicted. I do believe Rick Allen is innocent. However, they weren't allowed to give any information to the jury or present an alternate perpetrator theory to the jury because Judge Gull said they had not shown her a nexus, so something that actually connects, in concrete terms, alternate perpetrators to the crime. I disagree with that. I wholly disagree with that. However, Judge Gull spoke and ultimately Rick Allen was convicted. Secondly, we've very recently seen the Karen Reid trial where alternate perpetrators were in trial 1, because what we've just seen is the retrial. In trial 1, the defence went all out with an alternate perpetrator theory. They went all out and it resulted in a hung jury. And they made the decision to tone that all down in this trial, and I think they did the right thing. So although I believe that there are alternate perpetrators, because something happened to John O'Keefe, Karen Reid was found not guilty, something happened to John O'Keefe, someone did something to John O'Keefe, he didn't just get a fractured skull just by chance. Alternate perpetrators is a risky move for a defence, as the Karen Reid defence saw in trial 1. It perhaps confused the jury too much. So not using an alternate perpetrator theory sometimes actually benefits the defendant. But in this case, what the defence want to do is to introduce alternate perpetrators to the jury. And they claim there are 4 alternate suspects. Okay. The court concluded that at this time, defendant's alternate perpetrator proffer is inadmissible under Meister, as it's irrelevant and or excluded by Rule 403. However, this does not foreclose defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. Of course, the defense is allowed to cross-examine, that goes without saying. Okay, so one thing I do like about Judge Hippler is when he issues an order, he goes all out to explain really carefully why he's done what he's done. And this order is no different. Trial courts have broad discretion in the admission of evidence at trial. A trial court acts within the bounds of its discretion when it 1. Correctly perceives the issue as one of discretion, 2. Acted within the outer boundaries of its discretion, 3. Acted consistently with the legal standards applicable to the specific choices available to it, and 4. Reached its decision by an exercise of reason. Okay, this is Judge Hippler's analysis. The seminal Idaho case on the admissibility of alternate perpetrator evidence is Meister. Prior to Meister, a defendant wishing to present such evidence at trial had to first present proof of a connection with the crime, such as a train of facts or circumstances, as tend to clarify to point out someone beside the accused as the guilty party. So that obviously is a standard in Indiana, because that's what Judge Gull used to exclude the defence's alternate perpetrator theory from the trial against Rick Allen. Remote acts disconnected and outside of the crime itself cannot be separately proved for such purpose. Meister clarified that the Idaho rules of evidence, rather than the more onerous Lawson standard, control alternate perpetrator evidence admissibility. Under these rules, evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the standard more probable or less probable than it would be without the evidence. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence of its probative value if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Meister further offered the following guidance on applying these rules and determining whether proffered alternate perpetrator evidence is relevant and admissible. So this is quoting from Meister. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it's within the trials court discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to limitation provisions of Rule 403. A defendant has no right to present irrelevant evidence, and even if the evidence is relevant, it may be excluded in certain cases. So this effectively safeguards against the admission of just conjecture, vague inferences. And this is what Judge Hippler believes that the defence are doing. Okay, here, the evidence defendant has proffered, purporting to establish the four individuals and the alternate perpetrators, abjectly fails to meet the Meister standard. In addition, the evidence largely consists of inadmissible hearsay. Defendant contends, however, that under Chambers v. Mississippi, hearsay tending to establish third-party culpability may be admissible. Okay. Namely, the evidence is entirely irrelevant. It's very strongly worded. Nothing links these individuals to the homicide or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Three of the individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide, lived within walking distance of the crime scene, and were familiar with the layout of the victim's home from prior social events. All right, so we got to look at these footnotes here. The footnotes are important. So this is just regarding Chambers, regarding hearsay. In other words, Chambers indicates that due process requires hearsay rules to bend to evidence directly bearing on the determination of guilt. It does not hold that unreliable evidence may be admitted simply because it may be relevant to the defence case. As the court later stated, the accused does not have unfettered rights to offer evidence that is incompetent, privileged, or otherwise admissible under the standard rules of evidence. Alright, so we got a huge amount of redactions here. So footnote 2 is entirely redacted. So I assume footnote 2 includes the names and the circumstances by which the defence wants to introduce these three people as alternate perpetrators. As it's all redacted, I don't know whether perhaps he's exercising a bias. Without knowing who they are, it's impossible to say. We do have footnote 3. We got more redactions, but we do have a sentence here that's unredacted. The fact that these individuals lived within walking distance to the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspected killer. Listen, this bothers me. Even though I believe Bryan Kohberger's the guy, this sentence, well, two sentences, bothers me. Because Judge Hippler's already decided He has been the finder of fact here. He's already decided that the killer drove to the crime scene and the killer drove the white Elantra that's seen around 1122 King Road. Now listen, personally, I believe that Elantra was the suspect's vehicle, but I'm not the judge. I'm just here on the internet giving opinions. But what Judge Hippler has done here is supported the state's theory by saying, yeah, but the white Elantra is the suspect's vehicle, and that's who did it. But surely that's for the jury to decide. So I don't like this. Now, what else has been redacted? Obviously, I can't say. I don't like this. Let me know in the comments whether you think Judge Hippler has gone above and beyond his station here. Unless it's been stipulated by both parties that they agree, and I can't imagine that the defence has done that. You know, recently we've had a closed hearing. We don't know what went on there. So I don't believe that it's been stipulated that the perpetrator drove to the crime scene in the white Elantra. I'm pretty sure the defence would not stipulate to that. So, yeah, I don't like that. I really don't. Back to the main text. While perhaps this evidence could suggest an opportunity to commit the crime, i.e. living within walking distance, which no doubt is an opportunity shared by dozens of others in the victim's social circle, there is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them, or a means to do so. But nobody has to establish a motive. Nobody has to establish a motive. What was Bryan Kohberger's motive? And again, this is coming from somebody who believes he's the guy. But I'm not going to sit back quietly and just because this decision has gone in the favour of the state, when I believe the judge is overstepping, my humble opinion. Now, look, if I'd been able to read all the redactions, maybe it would make complete sense as to why the judge is saying what he's saying. But it's those couple of sentences in footnote 3. I just don't like it. I just don't like it. And saying there's no motive for these people, well, okay, that's fine. But nobody has to establish a motive. And what was Kohberger's motive? Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, provided DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. Yeah, but was all the blood tested? And we've heard that not all the blood was tested. To what end is Judge Hippler going to say that there was no DNA from them at the crime scene? They've been in that house loads of times. There's going to be loads of DNA. There's going to be loads of DNA in that house. Right? They can't swab every single surface and every single mark and every single blemish. But testing blood is, at a quadruple homicide, I think is a priority. The fourth individual did not know the victims but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. I believe this is Kaylee. Kaylee's family did say very, very early on in the case, before Bryan Kohberger was arrested, that Kaylee had a stalker, that there was someone that she was concerned about. So I think this is referring to Kaylee, unless it's another situation with a different victim, but that's what sprung to mind. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternate perpetrators, lab reports excluded his DNA from the sample taken from the crime scene and victims, and there is no evidence connecting him to the crime scene. Yeah, that one, I could understand why Judge Hippler has said that. You know, there's absolutely nothing like somebody who considered talking to one of the victims 5 weeks prior and has absolutely no other connection. Yeah, I think that's too remote. Collectively, defendants' proffer with regard to these four individuals fails to give rise to even an inference that they committed the crimes and otherwise make it more or less likely defendant was the perpetrator. Therefore, it's irrelevant under Rule 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feeling, means presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. Footnote 5. As the state notes, none of the four individuals drives a car that could be mistaken for a Hyundai Elantra. Yeah, but that's the state's theory. It doesn't necessarily mean that the killer had to be driving the white Elantra. Just because I personally believe the killer was driving a white Elantra doesn't mean to say that that information is a fact. That's for the jury to decide. I don't like this. Honestly, I don't. Unless there's actual evidence that nobody walked by, nobody climbed through the bushes, nobody could have possibly got to that house other than someone from the white Elantra. And if both sides have stipulated that that's a fact, and the jury must consider that a fact, then okay. But otherwise, I don't like it. But Judge Hippler continues. At best, defendant's offer of proof can give rise to only wild speculation that it is possible any one of these four individuals could have committed the crimes, which is inadequate under Meister. Again, mere inference that another person could have committed the crimes will most likely not be relevant. In other words, it's not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all defendant has done here. Look, if the evidence that they've presented is not strong enough, try again, do better. The trial, of course, is against Bryan Kohberger. The point I'm making, what I don't like, is that statement of fact. And the judge is not the trier of facts. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it's excluded by Rule 403. As the 10th Circuit noted regarding alternate perpetrator evidence, it is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. Likewise here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This foray would lead the jury astray, turning its focus away from whether defendant, the only person whose actions are on trial, committed these charged crimes. It's true, obviously, that there's only Bryan Kohberger on trial, but if you believe that it's the wrong guy, I can imagine that you're going to be fuming about this. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime. Finally, it will do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Nonetheless, the court's ruling does not preclude defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up on ruling out leads generally. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternate perpetrator analysis. So he's not slammed the door shut completely. You know, that is something that you've got to take away from this. If the defence can establish through cross-examination that the evidence collected was badly done and law enforcement ignored certain leads that would have led them in another direction, then yeah, that needs to be out there. I believe that needs to be out there in the open, and that is something that the jury does need to think about, absolutely. So this was a quote. We agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. That's State versus Book. It is further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying Meister, noting, while evidence Challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the only question in the case, whether Emerson killed James. So, in this case, whether Kohberger killed Maddie, Kaylee, Xana, and Ethan. The court will apply these same parameters at trial regarding defendants' cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Based on the foregoing, defendant's offer of proof re alternate perpetrators is denied. It is so ordered. Alright, what do you think? Are you a pro-Berger? Kohberger is innocent. If so, how do you feel about this? Do you think the judge is showing bias akin to what happened in other cases recently? I think the judge has overstepped for that one point. But I do agree, if everything relating to the alternate perpetrators is either hearsay or speculation, then no, I don't think the jury should have their time wasted in that way. But talking generally, cross-examining generally about the investigation without mentioning specific individuals, I think the defence should do that. Absolutely go to town on it. Because, failings in investigations need to be brought to the front. They do. Alright guys, let me know your thoughts in the comments, and I'll see you in the next video. And let me know if you want me to do a live stream going through the longer order from Judge Hippler, and also whether you want me to follow the Barry Morphew case. I'll be following it, but whether you guys want to hear my thoughts on it. Alright, I'm out of here. Bye guys. Good to go. Good girl. Thank you. Good girl.